Namaskar. Today we had a judgment from Supreme Court on the fate of Maharashtra Assembly. Now, ironically, one went through the judgment but understood literally nothing out of the judgment. So we have Mr. Viplav Sharma, who is from the Supreme Court, who is a constitutional expert, to help us understand, sir, what exactly happened in the court today.
I just got to see the excerpts that was being telecasted live on mainstream channel, but I could lay my hands on the judgment because it was immediately uploaded by the Supreme Court registry. And a quick glance I had before coming to your show, I thought that I should be having a best possible answers to satisfy the queries which possibly arise either through the judgment or in common parlance language. Also, one thing also I wanted to tell you about it. In some way or the other, I was kind of involved in this whole rigmarole which took place in June. And when the Shinde group, they went to other states and things were, everybody could foresee what is going to happen next. So I had an occasion to contribute what all limited knowledge I have on constitutional regarding the subject matter. I thought that I will go and visit the Shiv Sena, Mr. Thackeray, and give my opinion as to how you may consider to tackle the issue. I had good meetings with their legal brains there and even Mr. Thackeray. And there are 2-3 things which before I go into the judgment, I just wanted to give the background subject to you approving it. So I just advised or suggested, so to speak, Mr. Thackeray, is what all they have done, the Shinde faction, they should be immediately put on record. Record means in terms of the documentation which is recognized by constitutional law, which would be recognized by the judicial forums, including the apex court, and which would have a basis of the constitution bench judgments of the Supreme Court and the conventional issues which are being taken by other state legislature as well. So my first thing was that instantly, because if you recall how it has happened was that when these gentlemen, they were seen to be going outside the party. So I advised, or according to my opinion, it was that they should have been given officially a letter saying that you have, by your such conduct, fallen within the trappings of clause 1(2) of the disqualification, which says that you will be disqualified from your state legislature if you give up your membership voluntarily. So that such conduct is voluntary as recognized by Supreme Court other judgment. So therefore, that letter ought to have been given officially with the copies to the secretary, to the state legislature, to the governor, whosoever are involved in the appointment or election and appointment of the member of legislative assemblies. Be that as it may, it did not take place for whatever reasons. Everybody has their own perception to handle this issue. So that did not take place. Now the second thing which was there by the time, this was a day before when Mr. Thackeray resigned, because the whole issue of resignation of Mr. Thackeray was that these other faction have managed, so to speak, the minority of actual Shiv Sena. So in all probability, if the floor test would have taken place, Mr. Thackeray possibly would have been not able to prove his majority. In that circumstances, that time prevailing of what all has happened, everybody knows the facts. So possibly in order to avoid any embarrassment for the state legislature and constitutionally morally obliged, or whatever reasons he may have been advised, he resigned. Now the fact where we go into, now coming back to the judgment, and in this background, coming back to this judgment, there are three things which have certain issues which ought to have been espoused during the hearing, or it can still be done because these are constitutional matters. According to my opinion, constitutional law is a dynamic law; it is not a static. So, doctrine of state decis doesn't apply. So, what all has happened today would not mean that's the end of the road. You can still go to the court here. Yes, this is a fine judgment, but these are the areas if it can be further addressed because that when Constitution Bench is passing a judgment, according to my opinion, with all due respect and regard and with great deal of humility for the honorable court, they should answer in completeness, in absoluteness, so then such issue doesn't arise in future. That's the way I look at it. Now, if you have the judgment with you, the conclusive part, if you see, the first thing is that the Lordships has been pleased to refer the Nabam Rabia matter to the larger bench. There are various other issues, so that goes to a larger bench. Whenever it happens, it happens. Now, the second thing, the important thing which is there, which I am seeing it, is clause B in the conclusive part, that the court has held this court cannot ordinarily adjudicate petitions for disqualification under the 10th schedule in the first instance, which is very fine, because if you read, I think so, clause 6 of 10th schedule, the disqualification issue is to be dealt with by the Speaker of the House. So that's, and by virtue of the operation of doctrine of separation of powers between the legislature, the executive, and the judiciary, if the 10th schedule is within the realm of the state legislature or the parliament, so to speak, then the authority which has been given under the 10th schedule is with the speaker. If I'll just refer this clause 6, if I'm not mistaken. It's, yes, clause 6. Decision on question as to disqualification on ground of defection. So there the Lordship has very correctly held that let the matter be decided by the speaker. Now the whole question here is, if you see, all that happened from 22nd June till July, the speaker also got changed. The new speaker who has came in with the people whose I would say whose legality has been questioned today. So whether that speaker has been a justified person as of today, as we speak today after the judgment, would be a person to decide all these issues is a question also to be gone into. This is one. Now, second thing which I am saying is the important thing which this issue came to my mind pursuant to Mr. Thackeray's resignation, that and his lawyers were espousing status quo ante. I'm coming to that direct point, which like it is like Operation Successful Patient Dead kind of stuff thing has happened.
Correct.
So therefore, there are two things which has happened. One is that what all has happened, the Supreme Court has given its view with clarity that this is wrong, it ought not to have happened. Second thing, what they possibly have suggested, that had Mr. Thackeray not resigned, possibly status quo ante could have been
maintained,
which would have been granted. They would have considered it.
Sir, if I may ask you, and purely as a layman, sir, let me ask. I didn't understand the clarity because, see, sir, first of all, Supreme Court said that Shinde's appointment of his own whip was illegal. Number one, because the Supreme Court said political parties appoints whip, not legislative party. So Shinde's appointment of the whip was wrong. They said that the governor's intervention was wrong. Okay, with all this, they say part A was wrong, part B was wrong, part C was wrong, but the government still remains, which I didn't understand.
No, yes, that's where I'm coming. I'll possibly in layman's language I'll satisfy. Sure. See, now you have to take back the whole things as it stood on that date when Mr. Thackeray resigned. So that event actually took place.
Yes.
We can't deny that event did not take place. The event did take place. Mr. Thackeray did resign, and his resignation was forthwith accepted also by the governor. Now, the whole question which goes into this adjudication, which has taken place before the Honorable Supreme Court, and this judgment has come in, when the Supreme Court has declared that all that thing prior to Mr. Thackeray's resignation, they found it to be illegal, like the whip, the governor's order, they have very specifically, expressly, without any rider, they have declared it to be unlawful. They said that. Now, the question which ought to have been argued by, according to my limited opinion, by Mr. Shinde side, was that kindly see the timing and the facts. Sometimes you have to see the surroundings also. So my resignation did not come on my own volition. It did come after the date of the order of the governor who asked me to do the floor test. And after all that rigging has taken place, which rigging has been deprecated and has been negated by the Supreme Court by this order. So therefore, what has happened, since this thing was not espoused in the Supreme Court, so what the Supreme Court was left with was that Mr. Thackeray resigned and the governor had no other option but to invite Mr. Shinde for forming the government. So therefore, that part could have only been interfered by the Supreme Court if the Thackeray group would have said that once you are declaring that governor's order of calling for the floor test, Shinde's, and Whip all said, when we are declaring everything to be unlawful, so consequently, my resignation, which emanated from all these wrongful acts against me, has to be then declared as inconsequential and to no effect.
Correct.
Then only the status quo order would have come in.
Correct.
This thing was also suggested to the lawyers who, at that time when the matter was being argued, if I can share some other time, I can share my WhatsApp to you. But since this did not happen, but it still can. See, now there are findings now of the Supreme Court on the genesis of all this problem. And the Honorable Supreme Court has declared all this genesis to be wrong, unlawful, unconstitutional. The genesis I'm talking about. Now this gives them
Sorry. Please continue.
Now this gives the Thackeray group a leverage. It's a constitution bench judgment. Now they can still take up that issue. Since you have declared all this, now kindly see my resignation, though it was only in 3 lines that I hereby tender my resignation, as somebody was on the channel list, I got to know about it. But underline was that it was like a thumbscrew tactic that he was forced to give it. He, in order to maintain the dignity of the house, and dignity of the office which he was holding, he said, all right, if I'm not in a position until the time matter is pending before the Supreme Court, pending adjudication, if the conventionally I have to go. So but nobody can deny it. That resignation came only after the governor's order of asking the floor of test. So that by the time Shinde Group has already created the lobby and the majority with other party, etc. So he knew that floor test would be a sham and it would be very embarrassing for the proceedings of the House. So possibly that was the reason. But now, since the stand of the Thackeray Group has been vindicated in the Supreme Court, now is the right time, according to there is nothing goes wrong in even asking it. You have to move an application and say, this is our Lordship, this is what has happened. And if we are here before Lordship for your consideration, under Article 142, there are wide powers of the Supreme Court. They can still, if they want, to do a status quo ante. This is one part. The second thing which I want to say is that once they declared all these things to be unlawful, according to my opinion, the governor order ought to have been quashed also.
Correct.
Anything illegal or unconstitutional deserves to be declared null and void. It has to be quashed. Unconstitutional needs a natural declaration that it is being quashed. So once quashing would have taken place, that quashing would not be only the governor's order of asking for the floor test. There were other orders also, governor. He's asking for a summoning of the House. He's asking to do this. So all these things, once it goes, and consider the fact that Mr. Thackeray resigned, owing to all these things which the Lordship may consider They've considered, they've held it to be illegal. The only relief that it was to be judicially declared null and void has not, according to my opinion. I've just cursorily saw the release. I didn't find it. Subject to correction. Those orders, the wrongful actions, orders, they have not been quashed by the Supreme Court. They have declared it to be unlawful. But that's my opinion. I mean, their lordships are more wise. I don't know, they may have different reasons for that. But according to my opinion, as a lawyer and as an officer of the court, I would ask for the quashing if anything has been declared unconstitutional.
Again, going back to my original question, see, sir, while I'm sure they have reasons for it, but I don't understand as a layman what was the compulsion of the court to give such a verdict. Because again, coming back, Shinde's whip was wrong. Political party should be appointing a whip, not a legislative party. Governor's intervention was wrong. And after all this observation, the decision of disqualification goes back to the speaker. So, sir, if that was the case, if the decision had to go back to the speaker, then why have this hearing at all?
No. Sometimes it happens, I tell you. Sometimes it happens that the jurisdiction to decide the disqualification issue in terms of clause 6 of the 10th schedule is with the speaker.
Sir.
Now, speaker is what we are saying is the legislature side of the three wings of the constitution. And by virtue of operation of doctrine of separation of powers, the Supreme Court would not use up the power of the speaker to decide that issue. But at the same time, the Honorable Supreme Court, being a judicial forum and also the watchdog of the constitutional machinery of the governance, they can set the parameters, that these are the parameters you can't discount while to the speaker. That when you are considering that such disqualification is coming to you, that these are the parameters you need to observe, and these are the parameters you can't take into consideration. These needs to be negated. These needs to be disregarded. So that clarification has come in this order.
Sir, if that's the case, what obligation does the speaker have to actually take these parameters into consideration?
Now the question comes in. Now we are talking about, I don't know, because I slightly lost of the little facts, but you will correct me if I'm wrong. Now the question here is, who's the speaker lawfully appointed?
It is by the Shinde government.
So no. So that has been set at naught. See, please understand this.
Correct.
Now the whole thing has got back to the square one. Now we have to decide once. That's what the reason. When I'm saying that speaker and all these things have come in, so those orders ought to have been quashed. Then automatically, for the others, for the speaker and others who would not resign, who has been discounted, who has been rejected by Shinde Group factor, by the speaker or whosoever, those would automatically get reinstated.
Correct.
But the question did not take place. So the whole question will come in now, that which speaker, because every speaker owes an allegiance to a respective political party. So that's a problem which is going to, according to my opinion, will still be there. We will still staring to the issue. The thing which has to be done is subject to, again, this judgment needs to be reviewed few times to exactly understand what their lordship has in the mind when they pass the conclusive part of the order. But at the same time, prima facie, as I see, that this clarification is necessitated now. That I can understand, all right, let the speaker decide all this issue. Because, see, these are constitutional issues. It's good. Now we have actually started reading the Constitution after 1950. It's more than 70 years now. We have actually started opening the book and looking at the book, which is a good sign for the development, welfare, and the protection of the citizens' right. It's a good sign. So, and it will happen gradually, because now what the courts are facing it with is the convention, which is Westminster law, vis-a-vis constitutional scheme, which did not recognize Westminster law. So yes, they can't, in one hammer, they can't correct the whole system of this kind of a governance. So they'll have to tweak, they'll have to keep telling now, this is how you have to do it, this is how you have to do it. Now, if we have to actually give effect to this judgment, then it has to be given effect to the judgment in its true sense. I mean, that has to have its application for the welfare of the state of Maharashtra and consequently other states and consequently the nation. So therefore, this judgment cannot be seen as a theoretical thesis and it's been written. It needs to be implemented. And if we are talking about implementation, then we're talking about the citizens and people of state of Maharashtra, that where they have voted, how that their vote has been treated, firstly by the legislative side, the political side, the dispute arose, then by the judicial side. So this needs to be addressed. It cannot be just put in a locker and then all right, after about few months, the new elections is coming in and we'll see. So this comprises the legislature side, this comprises the judicial side, and this now comprises the public perception in a forthcoming elections. So if the one side or the other are going to use the judgment and they're going to continue to, with the arrangement which is as on date happening in the state government, chief minister and all that, then we are talking about the wrong thing which the Supreme Court has said is wrong, is allowed to be perpetuated till the next term election. We're talking about about a year or so. I think that October 23 elections are there, right?
Yes.
So therefore, I'm a citizen of the country. Assuming I'm based in Maharashtra, I'm a voter, I'm an elector. Why I should be allowed to live my life even for a single minute, forget day, unconstitutionally, and particularly such unconstitutionally which the highest court of the constitutional court has declared to be as such.
The court has observed that the governor's intervention was unconstitutional. So what happens to the governor then? He has done an act which is unconstitutional.
That's right. That's the same question. My wife, who's also a lawyer, also said that. See, the whole question is, once you declare that these are the things which is wrong, unlawful, then it is a solemn duty, according to my professional opinion, to declare it null and void. So once null and void takes place, then the things which replace the previous one automatically get reinstated.
Correct.
So what we are saying is that unlawful thing has prevailed over the lawful, but it is been declared as such that it is unlawful.
Correct.
We need to go further. So assuming, because these are constitutional things, it's a dynamic law. There might be 10 other ideas besides my way of thinking, your thinking, and every citizen's thinking to look upon it. So what I'm saying is that everything cannot be thought and said in one go. So in case now, see, the one part has come to a stand that their stand has been vindicated. Now, so that they have in their hand, nothing stops them to file a further clarification application or further relief or another writ petition based on this judgment.
Correct. So, sir, technically what we are saying is there is nothing that's going to happen to the governor for the unconstitutional intervention that he did. So, nothing technically could happen to it. That's number one. Number two is, sir, and my last question is going back to what you just said.
Judgment. I'm sorry, by virtue of this judgment.
Correct.
If other things are espoused before the Supreme Court, then it is the judicial wisdom of their lordships, whatever they will find good, they'll pass an order.
Sir, my last question to you, and I'm just asking you as a layman. I use this term quite often in this interview. I'm again asking you as a layman, sir. We've got around a year plus for our assembly elections in Maharashtra, like you rightly pointed out earlier yourself. Would we ever see any kind of judgment on this particular case, sir? Or this ball will just roll and roll and roll and roll, and finally we will go for another election? Is that what's going to ultimately happen?
I'll tell you, this judgment, practically speaking, serves Shinde Group. Practically.
Correct.
Till the time further reliefs are sought on an instant basis, that now since your lordship has declared this, so this has to come as a natural corollary instantly. So that can only be espoused by the other side, Mr. Thackeray's faction. So if they want to, so it's their it's their decision. It's their whether to instantly go and take the chances to say yes or no, or whatever they got, assuming they go further, something may get whittled down, or with this good thing in their favor by the highest court of the country, go with the public perception in the new election, and they confine themselves for about 12 months or about 12 months plus in whichever way the things are happening.
Pleasure talking to you, sir. What a pleasure talking to you. Thank you so much. And you actually decoded a lot of confusion in my head. Thank you so much for this.
Anytime. Thank you very much for having me over.